Hello, my name is Matthew Dunn. I'm a partner at Carter, Ledyard & Milburn. I previously introduced and previewed our video series from the firm's Cybersecurity and Data Privacy Group. This is part 2 in that series, which will provide an overview of the New York SHIELD Act. For this, I will turn it over to my colleague, Brielle Kilmartin.
The SHIELD Act is most notable for the breadth and depth of its application. Unlike previous privacy regulations, the Act applies to all data subjects that are residents of New York, regardless of the corporate domicile of the company collecting such information. Accordingly, the Act applies to many different types of companies, both foreign and domestic. The SHIELD Act is applicable to companies that collect or maintain private information of New York customers, defined as New York residents, regardless of whether the organization maintains a presence in the state. The SHIELD Act requires companies to develop reasonable administrative, technical, and physical safeguards to protect the security, confidentiality, and integrity of private information. The SHIELD Act, in fact, provides examples of these specific safeguards that can be considered sufficient and can be used as a checklist. Private information is defined broadly to include personal information that can identify an individual with one or more of the following: a social security number, a driver's license number, credit or debit card number, biometric information, or a username or email in connection with a security question and answer or password. The type of private information inadvertently disclosed or potentially compromised should be carefully assessed at the point that a breach is detected. The breadth of this new law's application and its expansion of obligations and requirements will have a far-reaching impact on organizations in New York and beyond the state's borders. And other states are expected to enact similar legislation. One question we often get asked are whether there are entities that are exempt from these requirements. And the answer is yes. The SHIELD Act is more flexible to what's defined as a small business, and it requires such a business only to have reasonable safeguards that are appropriate for its size, complexity, and the sensitivity of data that it stores or collects. A small business is defined as a company with less than 50 employees, less than $3 million in gross revenue for each of the past 3 fiscal years, or less than $5 million in total assets. Since the SHIELD Act applies to any entity with private information about a New York resident, regardless of where the entity does business or operates, this includes nonprofit organizations. So nonprofits should ensure that they have appropriate safeguards and breach notification policies in place, particularly since future regulations and laws are likely to be promulgated within and outside the state. Institutions and other companies covered by the Department of Financial Service cybersecurity regulation, which went into effect in 2017, generally must only comply with that regulation and are in fact exempt from the SHIELD Act. We are also often asked about the data breach notification provision of the SHIELD Act. A breach is defined as improper access by unauthorized parties that compromises the security, confidentiality, or integrity of such information, even if no evidence information was stolen or used for a malicious purpose. This includes information simply viewed without proper authorization. Under the breach notification requirement, you must notify consumers in the most expedient time possible without delay, following discovery of the breach. The method of notification must be by written notice or by electronic notice if the recipient has consented to receive it in electronic form, and so long as you keep a log of each notice that was sent. You may also deliver it by telephone, as long as you also keep a log of each notice. There are a few exceptions to the notice requirement if the cost of notice is substantial or the amount of customers that need to be notified would be overly burdensome to the company. Other exceptions to the requirement to notify those whose information was compromised exist when a breach was inadvertent by someone who had authority to access the information, and it's reasonably determined that exposure will not likely result in misuse or financial harm. And if notice is made to affected persons pursuant to breach notification requirements of certain other laws or regulations, including some federal laws and the New York Department of Financial Services cybersecurity regulation.
We hope that you find this video informative and helpful. For more information about Carter Ledyard and its Cybersecurity and Data Privacy Group, about the content discussed in this video, or if you have questions or need assistance, see our website at www.clm.com and contact us. Be on the lookout for part 3 of this series, in which we cover penalties and enforcement in New York.